So one of my subscribers notified me of this one. A man in Florida shoots his neighbor and claims self-defense. Today, he is a free man. We will hear first from a news report about the incident. We will ponder various angles on the case with an open mind. Then we'll hear from an utter moron about it. Want to guess who? Oh, and if you're a fan of his, please don't come in here crying, "Leave the man alone." Watch the video. Tell me where I'm wrong. Hello out there. I am trying to get through.
With cold, blunt analysis cradled in the warmth of reasoning, it's time for Johnny Walker Dread to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's time for the Johnny Walker Dread Show.
A father shot in front of his young son. Police say a neighbor pulled out a gun and killed him as that victim was doing yard work for his mother.
While I appreciate the news media's attempt to inject emotion into their reporting, the fact that he was shot in front of his own son has no bearing on guilt or innocence. Having your son nearby doesn't give you extra protection from physical force. And you can see why the word victim is problematic in a self-defense case, where we know the identity of the shooter. If the man shot is a victim, that implies that the shooting was a crime, which in turn implies that the shooter committed a crime. You can call a person who was shot a victim in other cases where the accused is claiming he didn't do it. Even the accused might agree that it was a crime. He just didn't do it.
Good evening and welcome. I'm Luann Sorrell.
And I'm John Brown. It happened last night when a 78-year-old man opened fire on Brian Ford. Ford's mother frantically called 911 right after he was shot.
I need emergency immediately. My neighbor just shot my son.
You said your neighbor shot your son?
Yes, he shot my son.
The shooting happened in a neighborhood in De Leon Springs in Volusia County. Fox 35's Connor Hansen has the details tonight with reaction from the victim's family. Connor.
John, today the sheriff called this crime senseless and one he does not think would be covered by the state's stand your ground law.
Not only do they call the person shot a victim, but the reporter here is calling it a crime. This is sloppy reporting.
And tonight, we're getting a glimpse into that suspect's thinking with a recording of what he told a 911 dispatcher.
Body cam video shows a deputy arresting 78-year-old Edward Druzalowski not long after they say he killed his neighbor.
My husband took his gun, but I think he meant to scare him, and I think he killed him.
Here's a tip. If you see your spouse shoot someone, call 911 and report a shooting, but be very careful about saying anything else. Here she said, "I think he just meant to scare him." If the husband claims something different, this could pose a problem for him. However, I doubt that they can call the wife to testify against her own husband.
Killed your neighbor?
I think so.
Witnesses say the victim, Brian Ford, was cutting tree branches by the property line and came to the other side of the fence to pick some of them up.
He walked towards me. He got really close to me, and he said, you or something,
Right.
pointing a gun at me. And I was pointing a gun at him at the time to get him off my property.
Right.
And then he kept walking towards me really close, so I shot him.
So it sounds like we have one of those cantankerous old men, get off my lawn types. Something happens to the brains of some old men that causes them to be super protective of their property. The man may have just been walking into the man's backyard to get some tree limbs. Most of us would evaluate the situation and think, hey, it's just my neighbor, and not worry about it. But old men sometimes act as if they've caught the dude trying to set their house on fire. Typically, what happens is the old man grabs a gun and thinks he's going to walk the neighbor around the yard with it. That upon seeing the gun, it'll be, "Oh, I beg your pardon. I'm getting back over to my property right now." Quite often, they're completely unprepared when their neighbor doesn't follow the script. And I think that's what happened here. Remember, if you pull a gun on someone, you better be prepared to use it. And by the way, what I said about the wife talking freely about what happened also applies to the man. He should not be making public statements like this. Get your lawyer involved from the very opening minute.
According to detectives, Druzilowski admitted his victim did not appear to be armed and that he hadn't threatened him. Two of the victim's sons were there when the shooting happened.
8-year-old was running around screaming, "My daddy shot, my daddy shot. You shot my daddy."
Senseless as senseless can be. Somebody's dead over tree branches. Are you kidding me?
Good old Sheriff Chitwood. I knew him back when he was the police chief in Shawnee. He came in, cleaned up the department, then blew out of town for Florida after only about a year.
On the phone with a dispatcher, Druzilowski seems to know he's going to be arrested.
I'm going to go to jail tonight, that's for sure.
Now, I have done some investigating behind the scenes, and the situation is a bit more complicated than what we have heard so far. But now, it's time to lower the IQ of the room, and for that, our beloved fraudster, Rashad Richey, is going to dip his oar in the water.
What if I told you that a man shoots his neighbor's son, gets away with it, claiming a ridiculous legal defense in Florida? Put up the picture full mask. This is an update to a story. Florida, a murder charge against a 79-year-old Edward Drew Zalowski was dropped Friday after he successfully argued that he shot his neighbor's adult son in self-defense.
The man's 8-year-old son was nearby and witnessed the shooting, so I think there may be some confusion because the man shot is also described as a neighbor.
Let me give you a reminder of what happened. The suspect was arrested in September 2023 after confronting a 42-year-old Brian Ford, who was on Edward's side of a fence. He was trimming tree limbs along the two men's property line. In a call to 911, the wife of Drew Zalowski said her husband, quote, just meant to scare him, end quote, when confronting Ford with a firearm. That's according to court documents. Ford, who was with his 8-year-old son, reacted aggressively, investigators concluded. The two men exchanged words, and Ford reportedly threatened the defendant with a chainsaw.
Reports that I've heard say that the chainsaw was not on. If it was electric, that means almost nothing. If it was gas-powered, I would think that would lessen the threat. But keep in mind also that a chainsaw is capable of dishing out pretty gruesome injuries. So even when not on, someone threatening you with it could still be a little scary.
Prompting Edward Drew Zalowski to draw the firearm. Edward told police he warned Ford and told him, quote, to get off his property. And Brian said something to the effect of mind your business, followed by profanity.
Not a smart thing to do when confronted with a gun.
The De Leon, Florida resident said he then aimed his gun at Ford, who allegedly responded, quote, you are pointing a gun at me. Are you going to shoot me? And move closer, Ford remained on Edward Drew Zalowski's property, inching closer until the neighbor told him, stop right now or I'll shoot.
Well, he asked, are you going to shoot me? He got his answer. The very fact that it was even a question should have told him, don't do anything to antagonize the guy with the gun. I mean, if this is true, and it's just the testimony of the accused, then Brian pulled a Rashad. If someone points a gun at you, you get the hell away from them. Don't antagonize him. Become very agreeable, but don't move closer to him. Sorry, but that's just plain dumb.
ABC News reported that Edward told investigators Ford continued to advance even after the older man dry-fired his revolver on an empty chamber. Quote, he said his firearm holds 6 rounds in the cylinder, but he keeps the first 2 empty for safety reasons. He stated Brian heard the gun click and continued to advance towards him, so he pulled the trigger a second time. He advised this time the firearm went off and he shot Brian, the authorities wrote to the court in 2023.
Now, if I'm the lawyer, I'm thinking, this dry fire argument might not work too well. because it sounds like the old man didn't realize that when you pull a trigger on a revolver, it advances the chamber before firing. So yeah, you're only going to get one gimme squeeze before the thug be good projectile comes out of the barrel. This could make this negligent homicide, because if he didn't know that, but he should have known that, then the death becomes his fault. This is why you always talk to a lawyer before you make any statements to anyone.
Now, I'm going to give you the defense in just a moment to properly contextualize what's happening. You have an individual with a gun who is threatening to kill someone because they have the audacity to trim tree limbs. That's what this is about. Cause and effect is important.
He doesn't understand the first thing about cause and effect. Rashad pulls this cause-effect fallacy all the freaking time. He was shot because he had an expired tag. Well, that's why he was pulled over. Obviously, police don't shoot people for having expired tags. The man wasn't shot because he was trimming trees. He was shot because he advanced on a man that had him at gunpoint. Or at least, that's what the accused says.
You cannot argue the effect and not analyze the cause. What is the cause? Pettiness. What is the cause? A lack of value for human life.
That wasn't the cause. Rashad can't get anything right. A lack of value for human life may have allowed this to happen, but it wasn't the cause. For it to be the actual cause of a shooting, the person would need to be a raving psycho.
I value the life of everyone involved more so than I would ever value the issue that we're arguing about. He was charged with second-degree murder. In his defense, Edward cited his age, physical condition, and the size difference between him and Ford. Ford's son turned out to be a key witness, telling police his father had threatened the elderly man.
This doesn't bode well for the case against the accused. If the boy is correct, his father did threaten the old dude. The
court determined prosecutors did not provide convincing evidence that Edward Drew Zalowski was not entitled to immunity on the basis of the stand your ground law, which says people faced with threats to their safety are not only required to retreat before, are not required to retreat before responding with force to a threat to their safety. The ruling has reignited a debate over the controversial law, which critics argue can lead to unjust outcomes in cases involving murky circumstances. Such laws have been linked to increased homicide rates.
These cases of stand your ground are so rare that I doubt that the law would increase homicide rates by any noticeable amount.
So I want to go back to the original defense. The original defense is not simply a stand your ground defense. The original defense is stand your ground contextualized through these other factors that aren't supposed to be highlighted, such as age, frailty, the inability or lack of capacity to fight. These are not supposed to be part of it. Here's why. Because it creates an inequitable dynamic in the law.
Where is he getting that? That isn't codified in law. Here are the Florida statutes regarding the stand your ground law. A person is justified in using or threatening to use deadly force if he or she reasonably believes that using or threatening to use such force is necessary to prevent imminent death or great bodily harm to himself or herself or another, or to prevent the imminent commission of a forcible felony. Now, forcible felonies are very serious felonies like kidnapping, arson, armed robbery, and such. A person who uses or threatens to use deadly force in accordance with this subsection does not have a duty to retreat and has the right to stand his or her ground if the person using or threatening to use the deadly force is not engaged in a criminal activity and is in a place where he or she has a right to be. Now, let's take a look at this. The man goes outside with a gun, and according to what I've heard, he points the gun at the neighbor. He's threatening to use deadly force, but he has no basis to believe that he's facing imminent death or great bodily harm. So on this count, it really looks like the homeowner has committed a crime. I would think that the homeowner could be charged for that. Now, does that negate his claim of self-defense? Well, it says here that you can do so if it's necessary to prevent imminent death or great bodily harm. Well, in this case here, I think that the man is reasonable in assuming that the other man, the neighbor advancing on him, is a threat of great bodily harm. The problem is provocation. Can you claim self-defense if you have provoked the threat? Well, every state has a different law regarding provocation. I have a video on that. I went looking through the Florida statutes. I could not find anything, so it's probably buried in case law. But you cannot assume that the man lost his right to self-defense by pointing the gun at the other person. It depends on what the law says. Age, frailty, medical condition can all play a role in whether someone fears great bodily injury. Rashad has no understanding of the law. He goes by gut feel, which in his case almost never works out.
Because this would suggest that under no circumstances could a particular individual ever be able to argue that what you did, sir, was actually murder. Because you have all these other frailties that the other individual does not have, meaning there's inequity in the law itself if it is applied successfully in your defense. That was one of the main arguments against stand your ground prior.
So let me get this straight. A little old lady in a wheelchair gets attacked by a 300-pound boxer, and she can't claim she feared serious bodily injury? Think about how stupid one must be to buy into Rashad's shady legal take. And I find it hilarious that Rashad, of all people, is casting shade on inequitable laws. This is the same guy who, if you asked, do you think that calling a black person a racially derogatory word should be a crime? He would say, absolutely. But if you asked him if the same holds for calling a white person a racially derogatory word, he'd say, yeah, let's not get carried away here. Everything about Rashad is inequitable law. When conservatives want hiring practices to be colorblind, who is the first one to complain?
That a young black male who's healthy and athletic could never utilize this type of argument against an older individual if the roles were reversed.
Why does the healthy male have to be black? Everyone involved in this incident was white. The guy just can't get off the topic of race. I'm telling you, he has a screw loose.
And now you have an actual court case that has allowed this kind of defense to be cross-contextualized in the defense of stand your ground as a reason for immunity.
You don't need a court case to contextualize. Rashad's favorite word next to quantum. Stand your ground is already the law. There have been plenty of stand your ground cases that preceded this one. And no, George Zimmerman's defense was not stand your ground.
What else do we have? In a very ironic way, the authorities all believed that this man committed murder initially. The prosecutor charges, the police arrest, there's an actual indictment, and then the argument before members of a jury, based on the statutory language of the law, creates an atmosphere that lets him go.
A few things here. One can be accused of a crime and still be innocent. Rashad is using the old, well, they charged him with a crime, so how could he be innocent argument we heard during Rittenhouse's trial. Essentially, Rashad is disrespecting the jury. But why does he even bring up a jury in the first place? The dropping of charges was ordered by the court, not the jury. In fact, I don't even think a jury had been selected for the trial. Keep in mind, this is the same man who claims a Juris Doctorate. That's right, a person claiming to be a legal scholar thinks that a jury ordered charges to be dropped. Let that soak in. I'm not sure there was ever even an indictment. Did the case go to a grand jury? Since Rashad claims there was, that probably means there wasn't.
What's really happening? Policy is allowing murder. That's what's happening. Policy is allowing murder.
No, Rashad, state statutes are not mere policy. The statutes are law. The concept of murder requires that the killing be unlawful.
Understand the cause and correlation. Where you have these ridiculous laws that allow for castle doctrine interpretation or stand your ground interpretation, these states also have increased homicides with these policies enacted. That's no coincidence.
How do you know it's not a coincidence? I mean, one could perform a study and decide whether the probability of it being a coincidence is low. but I haven't seen that yet. I highly doubt stand your ground has any measurable effect on homicide rates. The instances where someone claims stand your ground are exceedingly rare. Besides, it's not the homicide rate that's important. It's the unjustifiable homicide rate. I don't care if the homicide rate goes up if the people who are being killed were attempting to kill others.
Ben, when it comes down to it, it's simply inhumane to ever think that a neighbor is dead because of the trimming of tree limbs on a particular property line. What say you?
And Rashad falls back on, once again, the cause-effect fallacy. The cause of the shooting was the neighbor advancing on the homeowner, or it could be the homeowner firing a weapon without justification. But it's not the tree limbs. Now, Ben Gleib is going to weigh in. I don't know who he is, but his take is far more reasonable than Rashad's, because he appears to be a tad smarter.
I hear you, Doc. I have a different take on this story, just based on the limited evidence that I was able to, understand from the story. I think that, yes, the stand your ground law is problematic in some ways, but in this particular story, there also has to be some recourse that a man can take when he's being threatened on his own property.
You can almost feel Rashad bristling with anger. Hey, Ben, you might not be invited on Rashad's show ever again.
By a neighbor. And the man who was killed's own son testified basically against him, saying that he was threatening the elderly man. You threaten somebody on your own property, that's at your own risk. You do so while holding a chainsaw, that's at your own further risk. And the man, Kozlowski, who killed Ford, warned him he was going to shoot, fired an empty round first, fired a second empty round, and the guy kept approaching him, supposedly. It was what the trial seems to have come forward with, and said, "Are you going to shoot me?" Is cussing at him and threatening him worse. At some point, when are you supposed to be able to protect yourself from a threat on your own property?
Ben, I'm glad you brought that up.
No, he's not.
Because you had a different point of view when someone else went to a property and was the aggressor. Who was the aggressor in this story?
I mean, initially it sounds like Kozlowski was the aggressor of
that is correct.
Ford. Yes, but when it's on your own property, you have the right to ask them to leave. If they don't leave, you have the right to continue to ask them to leave. And if they become threatening, and if you're holding a chainsaw, which is a weapon that can easily murder somebody, at some point, you are defending yourself.
You have the right in 11 states to commit that crime and get away with it. Do you understand how policy contextualized the outcome of this? Because trespassing does not equate to your ability or capacity to murder somebody. It doesn't.
If the law in those states allows you to get away with it, then it's not a crime. As for the trespassing crime, Ben's point flew completely over Rashad's head. Ben clearly stated that the neighbor had threatened the homeowner with a chainsaw and had advanced on him. If the homeowner had simply shot the neighbor for being on his property, no one would be defending him. Remember, Rashad earlier said that the cause was the tree limbs. Now it's the trespassing. Rashad loves the word contextualize, but he is completely incapable of understanding the context of an act. He can only look at the end and beginning. Cops pulled over a black man for speeding. Cops shoot the black man. Therefore, the cops must have shot the black man for speeding. It is no exaggeration to say that this is how Rashad views the world. Now, make the man a white man, and his narrative changes completely.
11 states in this country will allow you to kill somebody and have immunity based upon a castle doctrine like stand your ground, a permeation of that doctrine. But once again, we're back to a policy dynamic, because remember, a grand jury agreed this was murder. Police agreed this was murder. The DA agreed this was murder.
This man claims to hold a Juris Doctorate. The grand jury, if they even held one, didn't agree it was murder. If you want to be a lawyer, Rashad, you gotta learn what a grand jury decides. The grand jury would have only agreed that there was enough evidence to try the accused. They don't issue a ruling on guilt or innocence.
And when you argue the facts before a jury with the statutory language of stand your ground, the prosecutor has to prove another element outside of the traditional element that would have been allowed prior to the policy being passed.
You mean laws change? Wow. The fact that the law said X and now says Y doesn't mean that the law is unjust, Rashad. Should we go back to the law of discrimination of 1860?
So my point to you is this, and I understand your disagreement. You're wrong. And let me tell you why you're wrong. You don't get to be the aggressor and threaten to kill somebody over something that's not even a misdemeanor, but an ordinance violation. And because you threaten that individual then threatens you back, which now you have a mutual combat situation, and you decide to use your gun to kill them. It doesn't matter that the that the first two shots did not shoot. We're taking at face value what the man is saying. We don't know if those first two shots were intentional to kill or not. I know that if you did this in Georgia, those first two shots are just as customary as if you tried to kill somebody. The only contextualization would be if I believed your story rather than the fact that you did pull the trigger twice. And that would, of any objective observer, would say, well, you just tried to kill a man with two bullets, but you got him on the third one. Do you understand that? Like once you pull the trigger, brother, you pull the trigger.
Yeah, but it might not align to state statutes. The laws regarding what constitutes provocation vary wildly from state to state. In some states, you have to be a total wuss if you carry a gun, meaning that you cannot do anything that would cause a conflict with someone else if you're carrying. In other states, the provocation must be such that it would provoke a deadly threat. In other states, your provocation has to be a criminal act, as it is in Wisconsin. And in other states, provocation only applies if the act was intended to cause an attack so that you could kill the man. What about Florida? I couldn't find any statutory elements on provocation, which means that I would have to dig into case law. I don't get paid enough to do that. If this discussion on how states view provocation interests you, I already published a video discussing it.
I mean, I think that's case dependent, yes, unless you can prove that you always did keep two chambers empty for warning and for safety reasons. I think, yes.
How would you prove that?
That is very hard to prove, but it's very hard to prove. So that's a fair point for sure.
That's the claim of the accused. Who has the burden of proof? Well, the prosecution does, but I think the accused would have to take the stand to make that assertion. Not sure.
But also, at what point, if somebody, God forbid, was on your property, Doc, and had a chainsaw and was coming at you and cussing, and you said, get off my damn property now or I will shoot you, and they said, you're going to shoot me, and got closer to you, at what point are you allowed to interpret that as a threat?
Once again, you leave out the element that started it. You don't get to be the aggressor and then cite a policy dynamic.
You can absolutely cite a policy dynamic. That's called a legal defense. Look the term up, Rashad.
What do you think Kyle Rittenhouse was about? Kyle Rittenhouse was an aggressor. He was an agitator who was then allowed, based on policy, to get away with shooting individuals that he was an aggressor against and being in illegal possession of a firearm at that.
Yeah, according to Rashad Richey, Kyle was the aggressor against Jojo Rosenbaum. Yeah.
Hi, I'm the most local person in here.
By the way, Rashad knows fully well that the gun charge was dropped against Kyle, but he also knows that his audience doesn't know that, so he'll just lie about it. He doesn't care about the truth. Now, it's going to get really stupid. Fasten your seatbelts.
Once again, it's trespassing, Ben. Ben, it's trespassing, brother. It's a trespassing crime. Call the police. It's a trespassing crime.
Rittenhouse wasn't on his own property, but the man's own son testified against his own father, saying he was threatening the elderly man.
He was an 8-year-old child who admitted that his father did utilize aggressive language back at the neighbor who came to him with a gun. I promise you, if somebody come to me with a gun, they're going to get aggressive words also, guaranteed.
Rashad, we know what happens when you do that. Did the neighbor not teach you anything? As stupid as we all can be at times, most of us are smart enough to hear a story about a man getting shot and thinking, perhaps I shouldn't do what that dude did. But not Rashad. He's so dumb that he would actively antagonize a man holding a gun on him. Rashad, do you not recognize the threat? Do you not realize that the man's trigger finger is only a couple of millimeters away from smearing your brains across the backyard? Of course, this is Rashad boasting how tough he is. Who in here thinks that if someone walked up to him, pulled a gun, and trained it on him, that he wouldn't be getting down on his knees in front of the man's crotch, willing to do anything to save his own life?
So the 8-year-old testified to the truth. Once again, the 8-year-old also testified that the neighbor was in fact the aggressor, that his father was simply trimming limbs, that his father was not the aggressor. See, these things are to be contextualized properly, dear brother. You can't dismiss them when, once again, in any other jurisdiction without the ridiculous stand your ground contextualization in Florida, this man would have been, in fact, not only arrested, not only indicted, but also convicted by a jury, given the statutory dynamics. The only thing that made this different is because of the stand your ground law, which, by the way, is echoed by the prosecutor, that it is the stand your ground policy passed by conservatives that made this outcome different than what the outcome would have been. So, Ben, what's the problem with that?
So the law was passed by conservatives. Yeah, So what? It's the law. Just because you don't like it doesn't mean squat.
Yeah, no, I mean, you make a good point for sure. And I don't think fatal force needed to be used. I'm just saying we weren't there. And this is on someone's property, which I think makes it a little bit
It's on the
different.
property line. It's on the property line.
On his side.
It's on the property line.
The fence is on the property line. Unless the neighbor was tightroping it, he was probably not on the property line, but rather in the neighbor's backyard.
So
I'm
let's
just saying,
talk about,
if somebody came at you with a gun, they're going to get harsh words. If I'm on somebody's property and they come at me with a gun, I'm getting off that property as soon as possible and not giving them harsh.
That's because you're smarter than Rashad.
well, okay. Well, that's why most states require that if something like that happens, you have a duty to retreat first. Do you understand why it's different in Florida? Like most states will say you have an actual duty to retreat if you feel as if there's a danger, only because that law requires that you care about the life of the other person. So you have this duty to retreat, which is eliminated in the Florida statute under Stand Your Ground.
Totally. And we can agree on this. People in Florida are aware of Florida's crazy laws. And so you have to be operating your life under the laws of the state in which you live. And so you have to take extra precautions to not fall victim to.
Well, that's an assumption not known in the facts, that he was aware of the statutory elements of the Stand Your Ground law. I'm not aware of all of the elements until I have to actually research it, look at element 1, element 2, element 3.
Gee, why not do the research before shooting off your mouth?
When it comes to a property line dispute, in a subjective way, the man may not have known, Ben, that he was actually violating a property law. Typically, you get 2 to 4 feet of an easement when it comes to property lines. And that's so that the government can come in and maneuver as they choose to within 2 to 4 feet. So you may have had an easement issue. Hell, this may not even technically have been trespassing, brother.
Okay, that makes no sense at all. I'm pretty sure that if I share a common fence with my neighbor, I cannot hop the fence into his backyard and claim it's an easement. So here's the Florida Senate's webpage where they cite the Florida statutes regarding easements. And I went through all these pages and I don't see anything that backs Rashad's argument. Maybe I'm wrong, but it just doesn't sound right. Perhaps we should go to Rashad's home, the one we found on Zillow that he tried to pass off as a research lab, and hold a barbecue on his property. We'll see how long this easement argument of his holds up. Well, that's enough dummy for today. Like my video and subscribe to my channel.